welcome everyone to another webinar with Richards and Jurusik. My name is Jeremy Richards, and I'm here along with Rebecca. And we are here to talk to you today about E1 and E2 visas. So thanks for joining us. Figure this out here. So just an overview of the agenda. We're going to be giving you an introduction as to what the E visa is. Then we're going to go in to some discussion on the E1 visa for treaties and treaty traders, the E2 visa for investors, the options for dependents if you have a spouse or children, also the filing options with USCIS as well as the US consulate, and the renewal and extension options for the e-visa, as well as letting you know about some upcoming webinars that we have coming down the pipe. So to start off, what is the e-visa? So E1 visa is designated for what they call a treaty trader. And a treaty trader is someone who engages in the trade of goods or services, including technology, between the United States and their home country. And here we're going to use the example of Canada. We do a lot of e-visas for Canadians. So it would be a Canadian company who is providing goods or services to the US market. And there are some criteria that you have to meet in order to establish your qualifications for an E1, and we'll go into those in more depth. But it's somebody who's conducting trade. And the important factor here is it's a foreign entity that is conducting this business with the United States. It's not a US entity. So it's a foreign entity conducting trade between the home country and the United States. Then the E2 visa is specifically designated for those who are investing in the US economy, in a business in the United States. And the two most common ways this is done is either through purchasing an existing business that's been in operation, doing business in the United States and employing US workers, or somebody who plans on starting a new business in the United States through a substantial investment in that business and in the US economy and creating jobs for US workers. And one of the advantages of the e-visa is renewable as long as the business remains compliant with the e-visa regulations, and can be renewed indefinitely.
So for the E1, as Jeremy pointed out, it's designed for individuals from treaty countries who conduct substantial trade with the US. And when we say trade, we aren't just talking about physical goods. This also includes services and technology. So, for example, a Canadian engineering firm providing consulting services to US clients. That's the trade of services, and that counts. So a key rule here is that more than 50% of the total international trade of the business must be between the US and the treaty country. So in other words, the company's primary trade should be flowing between the US and that other country, between those two nations. The E1 is particularly beneficial for existing Canadian businesses that already have strong relationships with US clients or suppliers, and they want to sort of finalize or formalize their ability to send executives or key employees into the US to manage and work at expanding those relationships. So in terms of requirements, like we pointed out, the applicant needs to be a citizen of a treaty country, and this applies to both the principal applicant and any employees that are later on seeking E1 status as well. Again, at least 50% of the business should be owned by individuals of the same nationality. Ideally, we're looking at the principal applicant owning at least 50% themselves and showing that ownership and control. The trade needs to be substantial and continuous, so not just a one-time transaction. It can't just be one big, large transaction. There needs to be an established pattern of multiple transactions over time. And lastly, the applicant needs to hold either an executive, supervisory, or essential skills position within the foreign entity.
Then that moves us over to the E2, and this is the E1 that Rebecca just spoke about. I think is the lesser known of these two visa types, but the E2 is the one for investors. So those that are investing a large amount of capital in the United States in a U.S. business, and Canadians or individuals from other treaty countries can qualify for the E2 visa as long as they have committed, and this is the very important part of an E2 investor visa, the funds have to be committed to an active business in the United States. What does that mean? Well, that means if you plan on starting a business in the United States or doing business in the United States, and let's say you're going to throw $250,000 at this business, you can't just go to the United States, put $250,000 in a bank account, and then say, I want an E2 visa because I want to do business in the United States. Here's $250,000 in the bank that I'm going to use for that investment. That's not considered committed. Well, what is committed? Committed, and I think the easiest way to explain it is you spent the money. So you have to have written the check, signed the purchase agreement, taken control of the business in the United States. So if that's an existing business, you signed the purchase agreement, you've committed the funds to that business. Or if it's a new business, you purchased a building, you purchased the signage, you have all of your equipment, you have taken all necessary steps to do business in the United States. And that active business part is very important. If it's an existing business, it's pretty easy to show that it's active. You're taking over this business. Typically, it's going to have employees and tax returns and a track record showing that it's an active business. For a new business, that requirement means that it has to be operational when they go to issue your visa. You have to have all the licensure and everything that's required in order to do business and hit the ground running when they approve the business, when they approve the e-visa. So very important that those funds be committed, that you actually have to spend the money and show that you've spent it. You got to show where you got the money from, and that it's been committed to this business 100% before they're going to issue the visa. And the person coming into the United States that's part of the registration process for the e-visa must be in a position to direct and develop that business in the United States. They want to make sure that whoever the investor is as part of this enterprise is able to come and ensure the success of the business in the United States. So the basic requirements are the individual has to be a citizen of the treaty country. So here we're talking about Canadians, so you have to be a Canadian citizen. And the investment amount, they don't give an investment amount per se. It's really in relation to the type of business. But typically the investment amount is no less than $100,000 and or more. So the smaller the investment amount, the more difficult it's going to be to show that the business is going to qualify for an e-visa. We have done them for less than 100,000, but typically those cases, let's say you're buying into a franchise and the franchise agreement to start a franchise, maybe it's a $75,000 franchise. They like franchises because franchises have an established business plan and typically have a track record for them to be able to look at to identify that this is going to be a viable business. If you're spending less than $100,000 and it's a brand new company, it's not a franchise, you're starting from something from scratch, that can be a little more difficult to prove the viability of that business. So the amount of the investment is really in relation to the business and what it would take for that business to hit the ground running and be successful in the United States. I use a hair salon typically as an example. Entry price for a hair salon could be, I've seen them around $50,000, $60,000. But then you have 3-4 chairs in that hair salon employing hairstylists. Well, that could meet the requirements for an e-visa and be approvable. However, if you're buying into a manufacturing company, your investment amount is going to be much larger than $100,000. It could be in the millions of dollars if you're investing into a manufacturing company, for example. So the investment amount all depends on the type of business that you're investing in the United States, as well as what percentage of ownership you have in that company. And to qualify, it has to be at least 50% owned by the treaty national and have control as well. So 50% ownership from the treaty country and ownership. And we talked about this a little bit earlier, but it must be real and operating company, and not what they call marginal. You can't just be setting up this business in the United States to create a living for yourself. So if you're doing an e-visa, investor visa here in the United States, and you just plan on employing yourself, your spouse, and let's say some family members or children, that's not going to meet the requirement for an e-visa. You actually have to create jobs for U.S. workers, and you have to have the intention of employing U.S. workers in the United States. They can't all be foreign nationals. And typically we say if this business doesn't have the present or future capacity to employ at least 3 full-time U.S. workers, then it's probably not going to meet the minimum requirements for an E2 investor visa. And one of the big benefits of the e-visa category, and this applies to both the E1 and the E2, is the dependent visa that comes along with it. And if you're a spouse, you would get an E1 or E1S or an E2S, the S standing for spouse, visa. And the spouse also has to be from the treaty country in order to get this. And what's going to happen is they will get an E1 or E2S that will allow them to work. And the work status is what is called incidental to status. They automatically are authorized to work in the United States, just like the investor or just like the treaty trader are. The advantage to a spouse, and I think this is a huge advantage actually the spouse has over the investor or the principal trader, is the spouse can work anywhere they want. They're not tied to the investment. They're not tied to the trade. They could get a position working wherever they want in the United States. In fact, they could, if they wanted, they could start their own business in the United States on a dependent visa. So huge advantage for a spouse is that they can do that. Now there are a few ways to get the spousal visa. The best way is to get it at the consulate. But if you are in the United States, there's ways to change status to get that status as well. But the best way is to get it through the consulate and obtain a 5-year dependent visa with that. And there is a way, and some people do like the assurances that if you are in the U.S. under that dependent visa, you can get an employment authorization document, or what is called an EA card, and the physical card that you can get that is proof of your status to work in the United States. Some people prefer that. Otherwise, all you have is a visa and a state that shows your permission to work. The card, when you present that to employers, can look a lot more official as far as proving your status to work in the United States. Although it is not required to get that EA card. Now, children under the age of 21 that are not married also can obtain dependent status. The disadvantage for a child is is not authorized to work for these. And both the spouse or children in the United States, if they choose to attend school, can do that on a dependent visa. And that dependent visa will be valid for the duration of the principal applicant's visa as well. So huge advantage for dependents. The spouses can get that work authorization, and children can accompany as well and go to school.
So when it comes to actually filing an e-application, there's 2 ways you can go about doing it. So the first would be through USCIS via a change of status. So this is only available if you are already physically present in the US in lawful non-immigrant status. So say if you're here as a visitor with a B, student as an F1, H1B, whatever it may be, you can change your status by filing Form I-129 with USCIS and requesting that change to the E1 or the E2. Now, processing time through this route can take quite a while. We're talking 10, 12 months. We have one that's been pending around that time right now. But premium processing is an available option. Of course, there's an additional fee, but that does guarantee a response, which will be either a decision or a request for additional evidence within 15 business days. So if you're looking to get here quicker and see a decision, premium processing is the route to go. The result of filing with USCIS is that you receive e-status, not a visa stamp. So what this means is you can remain in the US and operate your business, but if you leave the US, you need to apply for an e-visa at a US consulate before you can re-enter. So that's kind of the downside to filing with USCIS. The other option is going the consular route. So what this looks like, you file the e-visa package with all of your supporting documents directly to the consulate. They actually accept everything through email. If you are Canadian specifically and applying for the first time, you need to apply through the US consulate in Toronto. That is unfortunately your only option for those initial applications. Renewals can be done elsewhere. After submission and after the consulate has taken their time to review your application, you will be scheduled for an in-person interview. So you do need to go to the consulate, and a consular officer will review some additional documents and ask you just some brief questions about your eligibility. And as a result, then, if they decide to approve you, you will hand them over your passport. They will issue a E1 or E2 visa stamp in your passport, and that's what allows you to travel freely in and out of the US during your visa's validity period. So, in short, USCIS filing is convenient if you're already here and you don't plan on traveling soon, but again, it only grants status, not a visa to travel. Consular filing gives you that full travel flexibility, and generally it's a lot faster and more straightforward, especially for our Canadian clients.
Yeah, but I think the consular option is the best. You get 5 years instead of that 2 year.
Yep, that's another thing too. With filing at USCIS, you're going to be limited to an initial period of 2 years. You can renew that, but when you apply at the consulate, it's typically good for 5 years at a time. So that's another advantage. And this is just a chart outlining those key differences. So we have the location, USCIS filing. That's obviously inside the US. Consular is typically outside. Again, USCIS, E-status only. With the consulate, you get that stamp. The travel impact of filing with USCIS, your status is lost upon departure, which would require you to get that visa stamp. If you do that in the first place, you're free to make multiple entries back and forth. Again, processing speed, premium processing is really your best bet if you're going to go that USCIS route, but going with the consulate is going to be faster overall. And again, USCIS really only for individuals already in the US in lawful status, and consular is for individuals outside of the US.
And most of the time for Canadians, USCIS filing doesn't make sense because the border is right there, right? It's easy to go back. I think a lot of the people we see end up doing USCIS filing are ones where it can be difficult to get a consular appointment, or they don't want to depart the United States depending on the country that they're from and risk not returning to the United States. So when it comes to Canadians, we really don't run into that very often. And the vast majority of Canadians are going to opt for the processing at the consulate. And like Rebecca said, you're getting 5-year approval if you're doing it at the consulate versus 2 years with USCIS. Travelability versus no travelability. So big advantage for Canadians doing it at the consulate for sure.
And if we're looking to save money too, it's a lot cheaper going through the consular route than it is through USCIS, because with USCIS, you have all those filing fees on top of it.
Yeah, a lot cheaper. You can save like over $3,000, especially if you're doing premium processing. And frankly, if you do a case with USCIS, in my opinion, filing standard processing is crazy, because then you're at the mercy of USCIS. It could take forever. Like you mentioned, the case that's still pending after how many months? 10 months?
Yeah, 10 months right now.
you're crazy not to do premium processing. And that applies not just to E's, but also L's, TNs. USCIS will take their sweet time if they want to. So if you can avoid USCIS, we recommend it not only for E's, but TNs, L's. Stay away, avoid the fees, get it done faster elsewhere. So renewals and extensions. Uh, so both the E1 and E2 are renewable indefinitely. So this is just like the TN. There is no maximum renewal of an E visa. As long as the business is viable, you're continuing to employ US workers, then you can keep extending that indefinitely. Now, the difference, and again, we discussed this, if you're doing a USCIS one, you're only going to get 2 years, whereas if you do the consulate, they're going to give you 5 years. So big advantage if you do it at the consulate. And the renewal is contingent on doing business, employing US workers, and maintaining that investment in the business in the United States. As long as you have the tax returns, payroll records, and everything to demonstrate that this business remains viable and meets those e-visa requirements. And another key thing is don't change your ownership. If you give up your ownership in the company and you're no longer a majority owner, for an E2 visa, for example, well, you may no longer qualify. So if there's substantial changes in the company structure, it could jeopardize your e-visa. So be careful with changing your structure of your company after you get the e-visa. So as long as things haven't changed, you're still doing business, employing US workers, then you can renew this thing indefinitely. And travel, as long as you do it through the consulate, you can travel inside and outside of the country as much as you need while that visa is valid. One of the disadvantages, and this is the biggest disadvantage of the e-visa, and when people were discussing options, especially for business owners that may have a Canadian operation and a US operation, or want to branch into the US and they're trying to decide between an L1 visa and an E1 visa, is path to a green card. The e-visa does not have a path to a green card, either the E1 or the E2. They're like the TN in the fact that there is no direct path. They're all non-immigrant visas. One of the requirements, in fact, of the E1 and E2 is that you maintain your intention to return to your home country. And you have to demonstrate that intent as part of the visa application process. Actually, most of ours, we provide proof of ties to Canada or your home country, as well as a statement of your intent to return. So there is no direct paths to a green card through this process. So one of the disadvantages, so business owners, sometimes depending on your nature of your business, the e-visa may be the best fit for you because you have no intention of coming permanently to the United States. But if you do have a foreign entity and a US entity that are directly related and green card is potentially in the future for you, then the e-visa may not be the best path. You may want to look at the L1 visa instead, that does have a direct path for a green card for owners in certain positions within the organization. Thank you for tuning in today to this discussion on the E1 and E2. We gave a brief overview. We expect that you might have more questions about the E1 and E2 visa. We do these all the time with the consulate in Toronto and other consulates around the world, primarily with Canadians, though, through the consulate in Toronto, where these registrations are done. So if you have specific questions about an investment or your trade that you're conducting with the United States and whether or not that would qualify for the E1 or E2 visa, we can definitely answer those questions for you. So feel free to scan the QR code and reach out to us if you have any other questions. Also, we have some upcoming webinars where we are going to go more in depth into the E2 visa. This presentation today was a general overview of both the E1 and E2. So we're going to go into a lot more detail on the E2 for you and probably answer some of those more nuanced questions about the E2 in that webinar. And then the one after that, we will go into green card through marriage and the eligibility and process for that. Here's our QR code, our contact information. If you do have any follow-up questions or any questions in general about U.S. immigration, reach out. This is what we do. And we'd be glad to answer those questions for you. Thank you for tuning in today, and we look forward to meeting with you again next time.